beautiful interlude was very timely. So thank you very much, Sister Jasmine Bisnar. We proceed with the next segment of our program, which, like yesterday, is entitled Mediation Chat, Innovations in the Justice System. And here to share some thoughts with us are three very distinguished individuals who are very closely involved in the judicial system of Trinidad and Tobago. The Honourable Mr. Justice Andre Devines, the Honourable Mr. Justice Malcolm Holdip, and the Director of Public Prosecutions, Mr. Roger Gaspard, Senior Counsel. So I invite them to come forward. You probably sit here in the middle. Okay. Sure. Okay. Our first presenter to discuss the introduction of the Court to Next Mediation Program is the Honourable Mr. Justice Andre Devines, who is a High Court Judge in Trinidad and Tobago. Justice Devines was appointed a puisne judge of the Supreme Court in April 2009 and is chairman of the ADR Pilot Project Committee launched by the Judiciary in January 2013. He has joined the rank of certified mediators since 2007 in civil matters and has also been trained in judicial settlement conferencing. He has also been actively involved in judicial settlement conferencing of commercial matters awaiting trial. In addition to these distinguished qualifications, he is also a fellow of the Chartered Institute of Arbitrators of the United Kingdom, and in November 2014 continued his training in mediation, completing that training in the fundamentals of family and divorce mediation. He's been married for 34 years and is the father of 3 children. Although looking at him, I think he hasn't lost his youthful countenance, I must say. He's a Eucharistic minister at his parish of St. Anthony's in Pitti Valley and also a director and member of the faculty of the Foundation for Human Development, and is particularly passionate about the early introduction of mediation and judicial settlement conferencing into the judicial system of Trinidad and Tobago. It's Justice Devines.
Well, good morning. I've come to share my excitement with you. And the excitement is about the success of the ADR pilot project. This project, as you know, was started in 2013. It was launched in 2013 by the Chief Justice, and the report has been submitted. So I'm here to give you the good news. So I want to tell you about the success. I want to express my gratitude to all those who participated in the pilot project. And I'll tell you more about who those persons are in a while. And I also want to share my enthusiastic optimism about what is coming in 2015. And I say all of this with the approval of the Chief Justice, because I made sure that since I said last year, some of you may remember, that this was not just going to be another pilot project, followed by another pilot project, that I'm here to tell you that after pressing him, he has told me that I am authorized to say that Court and Next Mediation is coming in 2015. So let me tell you what I'm going to be sharing with you. First, I'm going to give you a little background about what was the background to where we've arrived, the project implementation, the project goals, the key findings, the project impact, and you'll hear a lot about how this is impacted on the parties, the attorneys, the judges, as well as the combined performance figures and the recommendations that have been made by our consultant, Ms. Kathy Gonzalez of Janus Conflict Management. First, let's go to the project background. The judiciary's mission statement outlines its commitment to work towards the resolution of conflict in the society by resolving disputes which arise out of the operation of the laws. And globally, as you know from hearing from the Canadian experience, as you know from the Jamaican experience of Mr. Bassi that he shared with us, that Quarternext ADR is being utilized to provide parties with a cheaper, faster, less adversarial dispute resolution process than litigation. Alternative Dispute Resolution pilot project was launched on the 23rd of January 2014, and 228 matters were referred to mediation and 100 matters were referred to settlement conferencing. It was supposed to be 200 matters, but in the enthusiasm of judges making referral orders, we ended up with 228. In terms of the project implementation, the pilot project was conducted in accordance with a practice direction which had been issued on the 17th of January 2013. The Dispute Resolution Center, for whom I have lots of praise, was contracted by the judiciary to provide mediation services. 16 mediators were selected by the judiciary after assessment and evaluation, and there were 4 co-mediators to conduct the mediations. There were 10 settlement officers selected to conduct the settlement conferences. And monitoring and stakeholder feedback mechanisms were implemented throughout the project. The main goals of the project were to assess the formal integration of mediation and judicial settlement conferencing under the CPR. Secondly, to assess the viability of outsourcing mediation services. And thirdly, to determine the most appropriate rules for the introduction of an ADR system under the civil proceedings rules. The key findings of this report and of this pilot project in terms of assessing the first goal of assessing formal integration was that 67% of the cases were completely settled or partially settled at an early stage of the litigation process, and 31% of the cases that were referred to settlement conferencing were completely settled or partially settled without the need for a trial. 83.6% of the judicial officers found that mediation was a useful tool in effecting settlement of matters in their dockets. 83.3% of the judicial officers also found that settlement conferences were helpful in effecting settlement of matters in their dockets. 98% of the parties and 100% of the attorneys were willing to utilize mediation again. 87% of the parties and 100% of the attorneys are willing to use settlement conferences again. In relation to the outsourcing of mediation services, the immediate finding was that the judiciary ought to outsource the mediation services until it can do it internally. Certainly that is going to require the judiciary in the future to begin the process of acquiring a mediation center and some other permanent space. I know that the Law Association has recently outfitted their building with mediation space. That is certainly something that we have to look into. And the judiciary should undertake to manage its roster of mediators. At the moment, with the outsourcing, the mediation agencies will be required to provide their own rosters. In relation to goal number 3, the determining of the rules for the introduction, the practice direction turned out to be very helpful to the court and to the attorneys. Certain amendments are required, and I can tell you from my conversation with the Chief Justice that that practice direction has been considered as a draft rule, and the Rules Committee has recently met, and that they are in the process of approving the new rule that would be included in the CPR. Let's look at project impact in relation to mediation. 435 matters were selected, notifying parties of the opportunity to go to the Quarter-Next project. Referral orders were made in fact, 228 matters, and the total after consolidation of certain matters was reduced to 222. 180 matters were completed. Now, in relation to the types of matters, there were many types of matters. There were land and estate matters, negligence, breach of contract, running down, debt collection, and a general category which we called other. And of the 180 matters that were mediated, 120 of those matters were settled, as I said, and 60 matters were not settled. So that's how we arrived at the 67% settlement rate. In relation to settlement conferencing, we also had significant settlement rate, but not as high as we would have liked. Was the process helpful? Was a question that was asked of attorneys and parties and judicial officers. And more than 80% of the parties found that the mediation process was helpful in all the categories of measurement. 90% of the parties felt that the process moved them towards settlement. 93% of the parties felt that the process encouraged the parties to be more realistic about their respective positions, and 81% of the parties felt that the process preserved the relationship between the parties. In relation to attorneys, at least 80% of the attorneys found the session to be very helpful or somewhat helpful in all the areas of measurement. In particular, moving the parties towards settlement, there was a response of 95%, and 93% in relation to the question of encouragement to be more realistic with their respective positions. 83%, as I said, 0.6, of the judicial officers found it to be useful. In relation to the performance of the mediators, this is a rating that was given to them. 89% to 98% of the parties who attended mediation rated the performance of the mediators as excellent or good. 96% of the parties thought that the mediator treated the parties fairly and was neutral and impartial. And 92% of the attorneys rated their mediator as excellent or good. And 98% of the parties said they would use it again. I want to share with you some of the comments that we had, just a few. Comments of parties. It helped move forward and close off in one day a matter that had been pending for a very long time. A great success. Another comment, closure at last while maintaining reasonably good relationships. In relation to the attorneys, and perhaps this may be a surprise to some, 100% of the attorneys indicated they would engage in mediation again. So whatever notions we may have had a few years ago that attorneys would balk at the idea of going to mediation because it would affect their pocket, and what other pejorative terms we may have used in relation to attorneys. The reality is, those who went, 100% of them said they would engage in mediation again. And when you get people like Mr. Jairam as converts preaching on your behalf, you know you have turned the corner. In relation to the kind of comments that the attorneys have made, allow the client, this is an attorney's comment, allow the client to see firsthand the other side's position on the issue and permitted the parties to arrive at a solution outside the parameters of the case. And significantly, another comment by an attorney was, shorten the dispute by 2 years at least. And you know there are many other cases that have been shortened by many more years than that. The impact of the settlement conferencing. Referral orders were made in 100 matters, and 87 were completed.